I'll mention.
Is it also pleasure to take up original side matter mentioning? What? Yes, mentioning, my lord. But that matter when I compelled to mention once again because Parsi rang me yesterday and they asked me to pay before your lordship to put the matter on 13th. He's coming on 13th of this month, but on Wednesday. But a small point is there, my lord.
Is it?
This is coming Wednesday, 13th.
He's coming to Calcutta.
Yes, he is coming to Calcutta, my lord.
For some other matter.
No, he is coming for this matter, my lord.
No, 13th is difficult for me, sir.
12th?
12th already we fixed. Continuing matter is there.
Small point is there, my lord.
Who is appearing for the respondent?
Mr. Duduria is appearing. Pitu Duduria. With Saurajit that I have spoken already to him, my lord.
And what is the point which is involved?
But DIN number was not put in the order passed by the income tax officer and served the copy on me without DIN number.
Oh.
That was the point we argued, my lord.
No, actually, there is some decision of Supreme Court.
Your lordship decision also is there, my lord. Subject to lordship.
No. Subsequently, Supreme Court has passed an order. It's a curable defect.
But that let it be placed before your lordship, my lord, subject to your lordship.
Already is coming listed on 13th. No, 13th.
13th. Yes, my lord.
My lord, may I be permitted to mention one original side matter, my lord, for correction of the order, my lord?
Original side.
Original side, my lord.
What is the correction?
My lord, only instead of revenue, it should be assessee.
Okay.
His appeal was...
Show it in the days list. Yes, it will be shown in the days list.
Okay.
And correction will be.
My lord, only one indulgence, my lord. In that matter, my lord, this is a change brief now. So, my lord, one liberty may be kindly provided for the learned advocate on record, new advocate on record to apply for the certified copy, my lord.
Vakalati is filed.
No, he has not filed the Vakalatnama. My lord, he'll file the Vakalatnama in course of the day with the department, my lord.
You file and then come to. Yes.
Grateful, lord.
Please call.
Appellate side matter, item number 1.
My lord, learned advocate, Mr. Sandeep Choraria, my senior, is appearing for the matter. Since my lord, learned advocate, Mr. Tanmay Choudhury is not present in the court.
What is the matter? Penalty?
So kindly defer the matter to Tuesday. Yesterday, my lord has deferred the matter, one more matter to Tuesday only, my lord.
There is some defect memo. Must you correct the defects? The learned advocate appearing for the appellant is directed to rectify the defects pointed out by the registry within a week. List so on so.
Grateful, my lord.
You see the defect memo and then do it.
Yes.
Item number 2.
May it please, my lords. I'm appearing for the appellant in the matter. But before I take my lord and my lady to the impugned order, may I indicate a few facts? Because, my lord, only taking your lordships to the order will perhaps, my lord, create an impression that the order is right. In fact, my lord, most of the ordering portion is correct. A part of it,
and
lord, is...
You're ready.
Lordship, kindly fix. I have argued this matter before the... Sir, from 7:59
I'm running.
Not sure.
We can come back on any other day, but may I only indicate what the matter is? I'll come back. But only this point, my lord. Here, my main grievance is, my lord, an individual. I'll without, my lord, going into the papers, I'll indicate. So there's a proceeding. There's been a default. The default being, there's an e-way bill which is not in dispute. Goods were supposed, my lord, goods were traveling from Calcutta to, my lord, Delhi, intercepted in Asansol. My lord, while they were intercepted, my lord, there were tax invoices and e-way bills which were given. My lord, with the tax invoice and e-way bills. E-way bills are not in dispute. That's, my lord, admitted. There was a physical verification of the goods, my lord, GST 04. There is nil discrepancy. So whatever is there, my lord, is reflected in the physical discrepancy, my lord, there is nothing. After this, my lord, the department, so my lord, we know there is some kind of a default because of which the goods are, my lord, kept. They're detained. We request that kindly give us the goods we are willing to pay under 129(1)(a) as the consignee. We were the consignee, the consigners was, was being sold to us. In transit, it was caught. It was detained, my lord. So we say we come up under 129(1)(a), we are willing to pay up this penalty and kindly release the goods in my favor. We showed the circular, my lord, the circular and clause 6 of the circular, who is to be a deemed owner. It is either the consignor or the consignee. We were also covered by your lordship's decision in Surajit Das, where, my lord, your lordship has, my lord, rendered a decision that in such a situation, if there is a dispute, even that cannot be looked into at this stage. It has to be given if to the person who is coming up because of the circular, deemed owner. The distinction now is, my lord, an individual who comes up and says that this Ghosh Enterprises, who is the one who's issued the tax invoices, is his. So he comes and says, I have not issued the tax invoices. I have never taken this registration. Very interesting, my lord. And that is where, my lord, the department is arguing that today the person who has given the tax invoice is coming and saying, I have not given this. So then there is a dispute. Then we can't deem you as the owner. That, and then, my lord, when this was argued before the Honorable Single Judge, the Honorable Single Judge very rightly, on this premise, has held that if there is a dispute, I cannot really go by the circular or by the Honorable Division Bench judgment in Surajit Das, where this issue is settled. But today the distinction is that someone comes up and shows that this tax invoice is not issued by him. I have twofold submission here, my lord.
Then what happened? You complete the narration of facts.
But then the penalty order is issued. The penalty under 129(3) is issued, my lord. We are not given the goods under 129(1)(a), and that order is passed. Our challenge, my lord, is that under 129(1)(a), we, my lord, are the deemed owners, and merely because the tax invoice, someone comes and says this is not my.
No, that is subject to investigation.
No, it's not. I'll indicate why.
No, that is subject.
But two documents. The reason, my lord, for the appeal is this: two documents were not considered by the Honorable Court. It was, my lord, it is perhaps not submitted properly.
You want the goods or you don't want the goods?
We want the goods, my lord. The goods, I stand corrected, my lord. The goods are released under 129(3), my lord. The order is passed now. My grievance is, my lord, at this situation, today, my lord, this individual, Siddhartha Ghosh, he is, my lord, the proprietor of Ghosh Enterprises. I have, my lord, on record, this was before the Honorable Writ Court also, my lord, on record, the Aadhaar card and, my lord, the registration. This individual has contended, he has put a signature, my lord, to the physical verification. This physical verification was conducted in the office of Ghosh Enterprises, where he was present. This individual says, I have nothing to do with Ghosh Enterprises. Then, my lord, the primary question which will arise is twofold. One, what was this individual doing then in Ghosh Enterprises? That's number one. Number two, the registration, he says, I never knew about the registration. His Aadhaar card is on record. The mobile number is on record. The moment there is a registration, there is an automatic message, an OTP, which goes to his mobile number.
The registration is not yet cancelled.
Not yet cancelled.
So he is a registered taxpayer.
He is, my lord,
dealer.
not cancelled, right?
Lordship, kindly.
It was not cancelled then. At that point in time, it was not cancelled, my lord. So
what
today,
did you challenge in the writ petition?
My lord, the entire proceeding saying, my lord, that today when we had, because my lord, we had filed the petition for release of the goods to begin with. Then, my lord, an order was passed in the interregnum. While the order was passed, my lord, we contended that this is also bad in law because 129(3) presupposes an intention to evade tax. My lord, there are judgments which we should have shown. My lord, perhaps it was an oversight that we did not. My lord, on that if there is an invoice raised and if there's an e-way bill, invoice is not required. If the e-way bill is there and that is not in dispute, then there is no intention to evade tax. Then, my lord, 129(1)(a) will apply, not 129(3). I want to contend that with those three judgments, and I'll rest my case. My only contention is
And
today.
on what ground the writ was dismissed?
The writ was dismissed only on one ground, that this individual has come up and said, Siddharth Ghosh, that I am not the owner of Ghosh Enterprises. These invoices were not issued by me. On that premise, our twofold submission was, my lord, negated. One, that, my lord, we are covered by your lordship's decision of, my lord, Shurjit Das, where, my lord, this issue, similar issue had arisen. The only distinction drawn out was, my lord, there, the person, my lord, issuing the tax invoice did not come up with a negative, my lord, contention that this was not issued by them. That was one. And the second point, the circular which binds them, my lord. The circular was negated. The honorable judge held that I would go by the circular, but the only problem is this individual coming and saying,
Admittedly, on the date when the goods were intercepted,
the registration was there.
valid. Registration was valid.
Was valid, my lord.
Lordship, e-way bill. Kindly look at the e-way bill and the tax.
I will come to that. The e-way bill is generated by this individual who says that I do not know about the goods. This is not.
So, until and unless you conclude that it was a case of a fraudulent registration or impersonation, this transaction cannot be
Lordship,
invalidated.
that proceeding will
Lordship-
be subject to correction, your lordship. That proceeding will be different because lordship kindly looks at the MOV 9, which is the order.
Page 95 is what I'll show, my lord. That is
14.
page 95. Kindly take up before that, my lord. Kindly see
Hmm.
the date, 1st August 2024, Siddharth Ghosh, GSTIN status active.
Hmm.
But that's the basis of my submission. This, my lord, is our fault, perhaps, my lord. We could
And
not.
when was it cancelled? Much
Any date? I'm sorry, my lord. I'll come back with the date. It is subsequently, my lord. That's my instruction. Subsequently, my lord.
and where is the penalty order?
Penalty order starts at 114.
114, my lord.
114 kindly looks at the last paragraph.
176 is, my lord, the
Lordship's query regarding
order.
what happened.
No, it's not 100. It's 120, 176,
114,
my lord.
114 is the MOV 9.
MOV 9 and the final order in
114.
connection is 176, my lord.
176. Here also 129.3 order. 130.
The 129.3, my lord.
129.3 MOV 9. 114.
No, 112, this is that's December 2018. I'm not on that. Hmm. Right. This is the penalty.
His case is something different, your lordship. If your lordship is at 114.
Why is he reading 100 in this part of the order? That's not the one you're changing. The one that starts from 106. No, I'm.
No, how we, see,
to-
based on the Ghosh statement,
Yes, your
you hold that the entire tax invoice is fraudulent without putting him on notice.
lordship. His tax invoices has been
Sir,
because
the onus is on Ghosh to prove that his ID proof was, that is his stand.
that is his
Somebody
standard.
misused his ID proof. Until that is proved in the manner known to law, this transaction cannot be invalidated.
But lordship, this registration certificate has not. Lordship is saying that we have to proceed against him separate proceeding.
Yes.
Lordship, then I have to take instruction.
No, he
whether
has
any
also
proceeding
filed
has been done.
returns. This Mr.
He's
Ghosh
filed
has filed
nil
returns.
return.
I have to come back with the
He
instruction.
filed a nil return.
He's filed returns.
I have to come back with the instruction whether any separate proceeding has
On
been.
the day, see, your order proceeds on the basis of a statement of Ghosh.
Yes, your lordship.
That Ghosh should have been put to cross-examination by the dealer, by the appellant. That was not done. You did not take any steps against Ghosh. See, first of all, a person who has raised the invoice, based on that e-way bill generated, there is no mismatch with regard to the quantity,
Quantity,
weight,
there was
etc.,
nothing. There was nothing.
identity of goods, nothing is disputed.
There was nothing.
He comes up and says, no, I have not got the registration. Then you'll have to,
He comes up and say, what happened was that, your lordship, on the consignor has been consistently filing nil returns. From there only we
Maybe, see, there may be so many issues. Unless and until you establish in the manner known to law that somebody used his identity, assuming he did some fraudulent transaction. And then he comes up before you and say, sir, I don't know, I didn't take the registration. Will you leave him alone?
Your Lordship, we have to issue proceeding. Whether that proceeding has been issued or not
What is the converse case here? On the date when the invoice was raised, after, see, invoice will be of relevance if the identity of the goods or the weight or the quantity,
These are the
etc. is in dispute. Based on that, e-way bill has been generated. You are intercepting a vehicle. So when you intercept a vehicle, if it had a valid e-way bill and whatever taxes are required to be paid as mentioned in the
has been mentioned. But your Lord,
you will have to first establish whether the stand taken by Ghosh is correct or.
I'll come back with the instructions. Kindly give me, because why I'm saying this, Your Lordship, because
And
a
what's
person,
the intention to evade payment of tax?
That's my case, my lord. There's no
Lordship,
intent.
if the entire thing is fraudulent, if the person who is supplying, he doesn't exist, some other person is.
He exists on the date when the invoice raised. What is his case? Somebody used my
Used
ID.
his ID.
So that,
So I don't know whether.
therefore, unless it is established, you can still say that I investigated the matter. You issue show cause notice to Ghosh Enterprises. He comes up with a reply. You adjudicate the matter. And if it is found the stand taken by him is false, what will happen to him? Now the goods are still lying with them.
No, they have been released.
On payment of?
My lord, 129 1B, my lord.
1B. Lordship, the
So that
difference
is-
being the owner and he's not the, we have.
So we have not been recognized, my lord, under
As the owner.
129 1A. So 129 1B is a higher tax which we
It's a
pay.
higher tax.
which we have
One
paid.
is 50% tax of the value, 50% on the
On the
value,
total amount,
and
that
200
is what we have
percent
paid.
on the tax amount.
You have just accepted what he says as
Whether any
gospel
proceedings have been initiated against Ghosh, I have to take instruction on that, Your Lordship.
on the date when penalty order was passed.
That
No
that day,
proceedings.
that day, no proceeding was there. But Your Lordship, I asked this question to myself that entire, like in other cases also, entire proceeding from the very initiation is covered by any fraudulent activity. Then what happens? If we detect during the course of the investigation, we detect something fraudulent is happening. So
You see,
It's
you
a
are trying to
question
put the
myself.
cart before the horse. You should have done this exercise against Ghosh Enterprises
Absolutely,
before
Your
holding
Lordship.
him guilty.
Simultaneously, it
And
should have been done.
what is the rate of tax, normal rate
But
of
we
tax?
would have paid 3 lakhs, which we have to pay, my lord, 29 lakhs. 5%, my lord, is the rate of tax.
Ah.
So it's ready-made garments, my lord.
Correct. But the rate of tax is 5%.
My lord.
And you have paid
Under 129 1B, we have paid, my lord, which is, my lord,
the value of the goods.
on the value of the goods, my lord. This is, my lord, 50% penalty. May I read the provision, my lord? It's 50%.
WBGST. This is uncorroborated, sir. You should have put him on notice. You are invalidating a e-way bill which has been generated online from your portal, and the registration is.
Lordship, MOF 7 किस कहाँ पर है? MOF 7 show cause notice. I did not find it show cause notice. Is it there?
Suppose notice is
It's at page 102. DRC 1.
Yes, you want. Lordship, if
Under
Lordship comes to
129 1A, my lord. %200% of the tax payable on the goods. That's what we are claiming.
Lordship is saying about the
Let me payment
notice, we have issued notice. In the
And against this order, you filed an appeal, no?
No, he has not. He has not filed an appeal. If Your Lordship kindly comes to 103, Lordship was saying that notice has been issued. We have informed in the show cause notice. We have informed them that this is our adverse finding.
Documents were never supplied along with that.
We could have very well asked for the documents, Your Lordship. If that was the contention.
Relying on the document.
Lordship kindly allows me to.
See, 103, second paragraph, it concludes with the sentence, this is a fake one. That is the stand of Ghosh.
That is stand of Ghosh, Your Lordship.
What did you do based on that stand? Will you accept? See, suppose, forget about them. You find from the portal that tax has not been paid or some verification you do. Then that particular dealer comes and says, sir, my identity proof of everything.
Absolutely, it should be done. I am with Your Lordship. Kindly allows me to come back with the instruction. Why I am saying this? Because at that time, whether I don't have that instruction in the present, at that time, whether any proceeding or any authentication.
Not go to that far. Even now, you might have taken action. Cancel. On what will be the relevant date? The relevant date when the vehicle was intercepted and the goods were retained.
Goods were
On that date, Ghosh Enterprises had a valid registration. They had raised a tax invoice. Based on that, the e-waybill has been generated and the goods were being transported. Then, for what purpose he took a stand, we don't know.
Why, Your Lordship, I am saying this. In GST, registration is not done. The person, there's no verification at the initial stage that the registration is done. There's no verification. Kindly let me submit then. GST, no verification at the beginning.
Now, the learned judge also proceeds on the uncorroborated statement. He says, I find ordinary tax invoice is sufficient proof of ownership. That is accepted. However, having regard to the fact, the named consignor and the witness having come forward and having disclaimed the validity of transaction.
Why I am saying this, Your Lordship, at the initial stage, with my limited understanding, in GST cases, when all the registrations or cancellation cases are coming up, there's no verification at the initial stage. Later on, when we see that there's something wrong going on, we go for verification. Our officers go for verification.
You accept to stand without verification?
Without verification?
Sir,
I agree with you, Your Lordship.
Forget about this transaction. The goods are being transported and there is some contraband inside. The vehicle is detained, intercepted, the goods are detained. Then that dealer comes and says, sir, I am not raised the invoice. I don't have a registration. Somebody missing. Will you leave him?
Absolutely not, Your Lordship. Absolutely
Therefore,
not. But Ghosh, whether any stand has been taken on the Ghosh on the day when the show cause notice was issued or intercepted, as Your Lordship has correctly said, during the date of interception, when we came to know that something is fishy or something is wrong, whether on that day any proceeding has been initiated or not, let me come back to that.
If that was initiated, you should have said that in your show cause notice.
And Milord, it is not there. Milord, MOV2 is in July 2024, Milord.
What is MOV2?
Milord, that's when the interception is done.
Where is it?
That's, Milord, that's recorded in paragraph 103, Milord, page 103. The document is at page 98, Milord. I'm only referring to this, Milord, for the date. Kindly see the top right-hand corner, Milord. It's 22nd July 2024. And Milord, in August, that's page 95.
You said 103.
No, Milord. 103 is referred in the show cause notice. The document is at Milord page 98. So page 98, I'll just show the date, Milord. It's 22nd July 2024, because the previous date, the first paragraph reads, as intercepted by the Assistant Commissioner on 21st July 2000. That's the date of interception, Milord. Now kindly see page 95, Milord. GST number of Siddharth Ghosh is active on, Milord, August 1, 2024, page 95, Milord. Page 95, top, Milord, updated on Thursday, August 1, 2024. The status is shown as GSTIN status active.
Department should have taken a stand that Ghosh cannot make such a statement.
And during interception only, they should have.
See, this is a very dangerous proposition, sir. A person who gets caught always will take such a stand. If the goods don't match, or there is some smuggled goods, place of origin is disputed, then you need to investigate on that.
Lordship, he is saying that a GSTIN was active. It might be, it is true, because a fake person is a wrong person according to Ghosh. another person was using his GSTI. That was active.
E-way bill
Investigation,
generated.
when was the investigation was?
Where is the reply to the show cause?
My lord. Is it page 170? No, wait. Kindly grant me a moment, my lord.
It's page 167.
167. My lord, 167. Yeah. Yes. This is reply to the hearing notice.
Reply to proposed order is at page 170.
167, my lord. And then page 170 is my lord.
One second, one second.
One 120.
Where is the circular?
My lord, this circular of 2008, you have a copy of
Circular
that?
dated 31.
140, my lord.
122.
148. Starts from 140. Serial number 6 is at page 144, my lord. Serial number 6. Serial number 6. My lord. And you'll
So circular applies.
my lord. And your lordship's decision is annexed to a reply. My lord, that's at page 146. Shurajit Das, my lord. At page 146, my lord.
No, that was the release of goods.
My lord.
Now that you have
Now
taken back the goods,
Cross that stage.
this is wrong. And where is the intention to evade payment of tax? There is absolutely no intention. So unless and until you are able to bring that under 129, the transports any goods or stores or any goods while they are in transit in contravention of provisions of this act or rules. Oh, this is ordinance already. Made that and all such
reading
goods
from which?
conveyance used as a
120.
means of transport for carrying the said goods and articles so on so on, shall be liable to detention or seizure.
Contravention.
And in fact, sir, give that GST. This is ordinance. All right.
My
What's
case,
the document? See, 129 can be invoked. Huh?
Lordship, in the rules, the documents are in the rules, Your Lordship.
Yes. Come to rule 138 capital A.
138.
Page 459.
Yes, Your Lordship. May I read it, Your Lordship?
Number 13. Yes, sir.
Any goods while they are in transit in contravention of the provisions of this act or the rules made thereunder.
The rules 138 1A says that, if I may read, Your Lordship,
Yes,
the
please read.
person in charge of conveyance shall carry the invoice or bill of supply or delivery challan as the case may be, and a copy of e-way bill in physical form. Or so invoice, Your Lordship, we are saying that the invoice itself is.
But invoice can be invalidated only if an inquiry had been conducted, and in that inquiry, the purchasing dealer should have been put on notice.
Lordship, inquiry
You
has been.
went by his uncorroborated statement.
Lordship,
You accepted it as truth, and you say, in view of the above discussion, where is the discussion? He walks into his office for some reason. Could be there is a dispute between on payment,
on
etc.
payment and etc. But Your Lordship, during the investigation only, Lordship has said that has fallen from Your Lordship. Whereas the investigation, we have gone for spot verification to his office, Your Lordship.
Maybe he's not there. Then
the only
but
lacuna in our.
still, if you accept this stand in respect of other transaction which he has done, on which if he has not paid tax, you cannot recover.
Lordship, there has
It's a
been lacuna.
dangerous proposition.
There has been lacuna in our part. I agree.
100%.
But whether any investigation has been, any proceeding has been initiated
No,
against him.
we need not go that far. We need not go that far.
There has been lacuna, Your Lordship.
And the learned judge also accepted the stand of the department or accepted the stand of Ghosh.
Learned judge said, Your Lordship, they have cited your judge. I'm carrying the judgment. That is a provisional release. Your learned judge has said.
That is
and Ghosh's stand, because on the very root of it, because any transaction.
Ghosh stand is he has not been given an opportunity to cross-examine him. You have held him guilty without following any procedure. Please come. This intra-court appeal by the writ petitioner is directed against the order dated 7/5/2025 in WPA 9544 of 2025. In the said writ petition, the appellant had challenged an order passed under that order. Where is that impugned order page number?
Impugned order is
Order impugned in the writ petition.
194, my lord. The impugned order, my lord, of the Honorable Judge.
No. Order impugned in the writ petition.
176, my lord. 3rd October 2024.
No.
Mob 9 order is at page 113. 113.
113, yes.
I'm sorry.
Why page numbers also you don't note and come? There is no index. Most clumsiest manner way of filing papers in the stay application. The appellant filed the writ petition challenging an order passed under section 129 within bracket 3 of the Central Goods and Services Tax Act 2017, read with the provisions of the West Bengal Goods and Services Tax Act 2017, hereinafter referred to as the Act, dated. What is the date of the order? Dated 21/7.
1st July 2024.
Pardon?
Page
130.
8 2024.
21/7.
21/7 2024 is the date given at page 113, my lord.
21/7.
The order
3rd August.
3rd
112.
August, my lord, 2012.
112. Page 112, 3rd August 2024. That is the form.
Dated 3/8/2024,
3/8/24.
by which penalty has been imposed on the appellant writ petitioner under section 129 within bracket 1 within bracket small b of the Act. The learned single bench declined to interfere with the
Interception.
order and rendered certain findings on the merits of the matter. But however, since there was an appellate remedy provided under the Act, relegated the appellant writ petitioner to avail such remedy. Agreed by the same, the appellant is before this court by way of this intra-court appeal. We have heard so much. The following facts are not in dispute. The appellant had purchased ready-made garments from Messrs. Ghosh Enterprises, for which a tax invoice dated 30/7/2024 was raised by the vendor, and the goods were to be shipped to New Delhi. And who are the petitioners? Sandeep Kumar Pandey is Sham Enterprises proprietor, is it?
My lord, he is the proprietor, my lord.
Who was second writ petitioner?
My lord, it's
Transporter.
and that's the transporter. The transporter.
Ah.
Your
Sham
track road
Enterprises.
transporter.
Come on. The writ petitioner being the proprietor of Sham Enterprises.
My lord.
The description of the goods have been mentioned in the tax invoice along with the HSN/SAC code, quantity, number of pieces, the price per piece, and the total amount payable, including 5% IGST, and the grand total being rupees 30, 190, no,
Well, 30,
30,
25,
25, 260. The goods were the vehicle which was carrying the goods, bearing registration number HR 38A B 7042, was intercepted by the Assistant Commissioner of WBGST on 21/7/2024 at 10 hours, 10:00 hours at Kalla More, KALLAMORE, NH2. The reason set out in the detention form, in form GST MOV-02 is with a view to verify the genuineness of the goods in transit, its quantity, etc., and/or tendered documents. Physical verification of the goods were carried out, and a report was generated in form GST MOV-4 dated 23/7/2024, and there appears to have been no discrepancy in the description of the goods as found in the tax invoice. Show cause notice was issued in form GST DRC 01 dated 26/7/2024, alleging that a spot verification was done by the state tax officer, Bureau of Investigation at the declared place of business of Ghosh Enterprises, and it appears that Mr. Siddharth Ghosh, the proprietor of Ghosh Enterprises, had stated that he does not run any business under the said under any GSTIN number, and the registration certificate has not been obtained by him, and the registration certificate has been fraudulently obtained misusing his identity proof. Based on this allegation, which remained uncorroborated, the authority, namely the Assistant Commissioner, came to the conclusion that the tax invoice furnished by the appellant writ petitioner is fake, as well as the waybill generated using the details in the tax invoice cannot be considered to be proper supporting document, and hence stands rejected, and the case is liable to be disposed of in accordance with section 129 within bracket 1 within bracket small b of the Act. Copy of the detailed notice was also appended to the said form. The appellant submitted a reply,
Lordship, if I may
dated 27/9.
reply from the order, it seems they have not filed a reply. That's why I wanted to correct your Lordship. From the order, page
No.
116,
Show cause they did not file a reply. To the hearing notice, they filed a reply.
hearing notice they have.
We strike out that. The appellant writ petitioner appears to have not filed a reply to the show cause notice, but when hearing notice dated 25/9/2024 was issued, they filed a reply dated 27/9/2024, contending that they had purchased the goods under the said tax invoice along and generated the e-way bill, and the same documents were submitted at the time when the vehicle was intercepted, and the tax invoice, e-way bill and consignment note shows the procurement of goods, shows the details of the procurement of goods, and that the appellant writ petitioner is the owner of the goods.
It's reply, but here you see in the order. You see in the order.
Further, the appellant stated that the payment details cannot be provided immediately because the payment in respect of the goods in question will be done within 2 weeks after the goods reaches the destination. The appellant referred to Rule 138 capital A of the WBGST rules and submitted that the vehicle, that the goods were being transported with the valid documents as mentioned in the said rule. Further, the appellant placed reliance on the circular, CBIC circular number 76/50/2018 -GST dated 31/12/2018 and a decision of this court. Once again, I missed the penalty orders, page 113.
May I assist your lordship with the page?
The circular is at page 140, my lord. Serial number 6, my lord, is at 144.
The authority, while adjudicating the show cause notice, came to the conclusion that the consignment was being transported without valid documents, which is in contravention of section 68 of the WB. It should be WB GST. It says
GST.
WB VAT Act,
GST, my lord.
page 115. The paragraph in uppercase, capitals. In contravention of section 68 of the WB GST Act and rule 138 capital A of the WB GST rules, and attracts penalty under section 129 of the Act. On going through the show cause notice, we find that the authority accepted the stand taken by Mr. Ghosh as gospel truth, inverted comma, without conducting any verification and without putting the appellant writ petitioner on notice about the stand taken by Ghosh Enterprises, and straightaway proceed to hold that the transaction was, that the transport of the goods was without valid documents. It is rather surprising as to how the department accepted the stand taken by Siddharth Ghosh without any verification on the date when the goods were detained, comma, on the date when spot inspection was made by the authority in the premises of the Ghosh Enterprises, and more particularly when the GSTIN of Ghosh Enterprises was active as of August 1, 2025. Assuming a case where goods are being transported and there is suspicion with regard to the place of origin of the goods or such other matters, normally the tax authorities cause verification. And if the consignee / selling dealer takes a stand that he has not issued the tax invoice and he has no role to play for the transport of the goods, immediately the department will cause verification of the correctness of the stand taken by the consignee / selling dealer. It is full stop. In the case on hand, it is rather surprising that no such verification was caused before issuance of show cause notice to the appellant writ petitioner, and they accepted the stand taken by Mr. Ghosh as absolute truth. The authority has erred in doing so, which has ultimately resulted in an erroneous order of penalty. Rule 138 of the, no, sorry, before that. Section 129 deals with detention, seizure and release of goods and conveyance in transit. Subsection 1 commences with a non-obstante clause stating that notwithstanding anything contained in the Act, where any person transports any goods or stores any goods while they are in transit in contravention of the provisions of the Act or the rules made thereunder, all such goods and conveyance used as means of transport for carrying the said goods and documents relating to such goods and conveyance shall be liable to detention and seizure. And after detention and seizure, they may be released subject to the conditions in clauses A, B, and C, small a, small b, small c, within bracket. in subsection 1 of section 29. Section 68 of the Act deals with inspection of goods in movement. Subsection 1 of section 68 states that the government may require the person in charge of a conveyance carrying any consignment of goods of value exceeding such amount as may be specified to carry with him such documents and such devices as may be prescribed. Subsection 2 states that the details of the documents required to be carried under subsection 1 shall be validated in such manner as may be prescribed. Subsection 3 states that where any conveyance referred to in subsection 1 is intercepted by the proper officer at any place, he may require the person in charge of the said conveyance to produce the documents prescribed under the said subsection and devices for verification, and the said person shall be liable to produce the documents and devices and also allow the inspection of goods. The documents and devices which have been are as prescribed under Rule 138 capital A of the rules, which deals with documents and devices to be carried by a person in charge of a conveyance. Sub-Rule 1 states that the person in charge of a conveyance shall carry A, small a within bracket, the invoice or bill of supply or delivery challan, as the case may be, semicolon, and B, a copy of the e-way bill in physical form or the e-way bill in electronic form or mapped to a radio frequency identification device, sir, RFID, all capitals, embedded onto the conveyance in such manner as may be notified by the Commission. It is not in dispute that the appellant and that the vehicle on the date when it was intercepted and the goods were detained, the documents to be carried as stipulated under section 138 capital A within bracket 1 within bracket A and B were carried by the transporter, who is the second appellant writ petitioner. Therefore, on the date when the goods were vehicle was intercepted and goods were detained, there is no contravention of section 68 read with section Rule 138 capital A. If such be the position, that rule section 129 would have no application to the facts and circumstances of this case. Apart from that, the department has not been established or has not been able to establish that there was an intention to evade payment of tax by the appellant writ petitioner, which is a prerequisite to invoke the power under section 129 of the Act. The circular issued by the CBIC dated 31/12/2018 is of relevance. The circular has answered certain issues, has clarified certain issues. In serial number 6 of the circular, the issue was, inverted comma, who will be considered as the owner of the goods for the purpose of section 129 within bracket 1 of the CGST Act. Question mark. It was clarified that if the invoice or any other specified document is accompanying the consignment of goods, then either the consignor or the consignee should be deemed to be the owner. In the instant case, the invoice and the stipulated documents clearly show that the goods were consigned to the proprietorship firm of the appellant writ petitioner, and for all legal purposes, the appellant writ petitioner is deemed to be the owner of the goods. It may be a different case if the department had caused a verification of the stand taken by Ghosh and come to taken by Ghosh and before coming to a conclusion that his stand is correct, the appellant writ petitioner ought to have been put on notice. Otherwise, it would be in violation of the principles of natural justice, as the appellant is being condemned without being heard. If the procedure adopted by the department in the instant case is followed in other cases, it may lead to various other consequences, which undoubtedly would be against the interest of revenue. It appears that subsequently the registration of Ghosh Enterprises had been cancelled. However, there is no record placed before the court to support such a stand. Even assuming the registration certificate of Ghosh Enterprises was subsequently cancelled, it can have no impact on the genuineness of the transaction done by the appellant, as the goods were detailed for the purpose, as the vehicle was detailed along with the goods for the purpose of verification of the genuineness of the goods in transit, namely its quantity, etc., and / or tender documents require further verification. Therefore, the action initiated against the appellant writ petitioner based on an uncorroborated stand taken by Siddharth Ghosh is wholly illegal and unsustainable in law. For the above reasons, the appeal is allowed, order passed in the writ petition is set aside, and the order imposing penalty under section 129 1B is set aside, and the respondent department are directed to refund the penalty collected from the petitioner, appellant writ petitioner, within a period of 8 weeks from the date of receipt of the server copy of this offer. Next.
My lord, I'm appearing for the petitioner.
Yes,
My
madam.
lord, I'm grateful.
How are you, madam?
My lord, I had my knee replacement surgery and now 2 months over. I'm appearing online.
Actually, after knee replacement, within 2 days, they will make you walk.
Yes, my lord, they made me walk, but my lord, my legs were not very stable.
No, don't sit at home. Come to court. Then only it will be better.
My lord, I will.
Since
I'm very
Mr.
deeply obliged. May I file the affidavit of service, minutes?
Yes.
I was under the impression, Your Lordship, since Mr. Chakraborty is not there, Lordship
Your
will-
name in capital letters.
No, Lordship will go lightly on, not very stringently on me. But this is a very
No, what you should do, see, you forget about this. You tell the officer, every errant dealer, when once he is caught, he will say, sir, somebody misused my ID. You will not leave him. You see under VAT also, you will not leave him. What you will do is immediately go ask him to establish that
show cause notice should have been what I go through.
if he had filed a criminal complaint. There was one case, I remember, there was a criminal case filed and that fellow was arrested, something all happened.
Criminal complaint
So
should have
this
been
is
simultaneous.
It's not a genuine stand. This is basically a dispute between the vendor and the purchaser. Money transaction. So what he thought the best way to do it is, because Asansol, that area, NH4, vehicles are all detailed. I mean, all vehicles are intercepted. Random checking will go on. Without documents also, vehicle will move. With documents, the vehicle will be detained. We know the checkpost story and all.
I regularly travel in that way. My parents stay in Jharkhand, so I drive by car, and every time I see there's a checkpoint and something is happening.
You get caught in the traffic jam, 3 hours, 4 hours gone.
Much obliged.
Deeply obliged.
Next.
Grateful, my lord.
Item number 3, I appear for the petitioner. But there has been a
Last
violation
time.
of your lordship's.
You have served notice? No, you will serve.
Not, sir. There has been an order dated 20 February 2025, and your lordships are directed at paragraph number 5. That strict actions has
Lock
been
the
taken
wheels
to
of the
lock.
illegal. Strict vigil. All right. The learned advocate appearing for the applicant is directed to serve notice on Mr. Nilot Chatterjee, who appeared for the state in the writ petition, and Mr. Devayan Sen, who appeared for the respondents 5 and 6 in the writ petition. You serve notice on the advocate. Huh? Next.
Item number 4.
I told him
I am the respondent, my lord.
tomorrow we will fix it. Tanay Chakravarti is not available today.
Saptak is here, my lord. They are. Saptak,
No, he is not ready. He said he is not ready. In fact, advance adjournment was taken by Chakravarti. All right. At the request made on behalf of the learned advocate for the appellant. Let it come in September monthly list.
September.
There's
The
no
refund,
time.
my lord, I am basically losing my from last 17 years. They are not refunding my.
It is safe with them. Don't worry. Yes. Appellate side over. The original side.
Impugned order dated 22nd, 2020.
It should have done it. So, okay. What is this to be mentioned?
Well, this matter your lordship has taken up earlier on 2nd July 2025. Only the memo of appeal has been filed without condonation of delay. Now, I pointed out before your lordship that this order is relating to of 22nd December 2015, and thereafter your lordship directed the department to reconcile the.
And who will appear for this?
Nobody is
Gold
appearing.
Star?
Nobody is appearing.
3026.
Yes.
My goodness. This is the highest.
Yes, sir. Benchmark.
There is no application.
No application, nothing of the sort.
Reference may be made to the order dated 2nd July 2025, which reads as follows. Please record the order. When the matter was heard on 2nd July 2025, none appeared for the appellant, and the respondent department was represented by the learned senior standing counsel. As we found that the computation of delay was incorrect, the registry was directed to
recompute
the delay. Accordingly, the delay has been recomputed, and there is a delay of 3026 days in filing the appeal. No application for condonation of delay has been filed. Even assuming a stand is taken by the appellant, the delay of 3026 days is inordinate, and no grounds have been made out to condone such an inordinate delay. Accordingly, the prayer for condonation of the delay.
There is no prayer. There is no condonation of the application. Since there is no application,
stands dismissed.
Yes.
On the ground of inordinate delay. Next.
Grateful.
Item number 2.
For that. Mr. Junivala wants some corrections in the order.
He wants, I think the entire order has to be corrected.
No matter there's some, but also handed over a separate a write-up as well as my lord the changes with corrections indicated in pencil, your lordship.
What shall we do? We shall.
But actually, some factual. If I can just take my lords through the.
Not required. He has made the pencil corrections. We will make that. And so we have to take this off from the server and upload. Matter has been listed under the caption to be mentioned. It is pointed out by the learned advocate appearing for the respondent assessee that there are several typographical no, we'll fix the bushes tomorrow. Typographical mistakes in the order, and some of them mistakes in the order which needs to be corrected. The following corrections shall be effected in the order dated 9th July 2025. If you can give a soft copy of this,
I'll do that right away.
We will incorporate.
I'm providing right now,
This one you incorporate. This
I'll
order shall form part of the order dated July 9, 2025. Since the corrections are to be made in several paragraphs and in several places, the order which has already been uploaded in the server shall be removed, and the corrected corrected, and the corrected order shall be uploaded, which shall form part of the order dated, which will be in substitution of the order dated 9th July 2025.
I'm grateful, your lordship, and I'll provide a soft copy immediately, your lordship.
Next time you can.
Grateful, your lordship.
For hearing of all cases, item number 3.
Lord, item number 3, Mr. Maiti was appearing. Probably they've also filed their paper book, my lord, but I don't have any records, my lord. This is the problem I am.
You can provide him one copy.
इंडस्ट्रियल तो ये तो आपका हिंडल को वाला मैटर है ना हाँ थे हम तो माइक सर के कॉपी पूरा था मेरे पास कोई कुछ नहीं है वो दे पातला जी नहीं जाते कुछ भी नहीं है
All right. We have heard so and so. The learned advocate appearing for the respondent department submits that they do not have papers in the matter. Let a copy of the paper book filed by the appellant be provided to the learned standing counsel for the respondent within a week.
I'm led by Mr. De, my lord.
Kaushik De and Topan Vancha. Sir, give a date after 2 weeks.
My lords, all papers are in the stay petition only. We have not filed anything separately. All papers are in stay petition only. We'll
stay petition, not
give them.
ठीक है वो stay petition 2 weeks. Grateful, my lord.
Item number 4.
4.
Order sheet also. So none appears for the appellant, SSC. As could be seen from the earlier order, none appeared for the appellant. Dismiss for non-prosecution.
Item number 5.
Item number 5, I'm appearing for the appellant, my lord.
My lord, I am for the appellant, having Mr. HON'BLE. My lord, in this matter, very short question is there, my lord. If your lordship takes up the question of law, then
It's 33, my lord.
my lord will have to consider Rule 7, Sub-Rule 4 of Senate Credit Rules 2001, 2002, my lord. There, my lord, 1st March 2003, the word procured has been replaced by the word purchase. Now, what happened here? The assessee, my lord, received certain noodle of soap, my lord. Now, my lord, he enjoyed the Senate credit. He is not the manufacturer. That's why the department.
No, but then in the statute, what they say, the tribunal says is the word procured.
Yes, procure.
Substituted for the word purchase.
Yes.
Procured can be in any manner.
But my lord, procure means, my lord, for the purpose of, my lord, some job work. My case is that
No. How to interpret it like that? And you have lost before the commissioner, and then you came before the tribunal. Tribunal also dismissed it. Where is the commissioner's order?
Commissioner is against me, tribunal also against me, but my lord, I am only simple
Page
question.
number.
Put this question to me, my lord.
Page 13 is
If procure and purchase are the same thing, my lord, then I think
No.
legislature would not, my lord, change this word procure by
No,
replacing
if it is same thing, why they should substitute it?
My lord, that is my lord. Then, my lord, my question is, I am joining the question now, my lord, that then he have to purchase it. If he purchase the goods, can he avail the Senate credit? He nothing, only servicing here, job working has been done by the SSC and availing the Senate credit. That is my assertion.
The rules are there.
The rules.
You give the thicker book. You give rule 57 capital A.
My lord, it will be in the central exchange. I have got it from website. Not on the whole the books, but the relevant provisions are there, my lord.
But where is that substitution?
Well, substitution is sub rule 7(4). That was
My lord,
2003.
by way of a notification, it is recorded by way of notification, my lord.
That is not here.
That is not here, my lord. Notification is not here.
In that book, it is not available.
No, my lord.
No,
The
we are-
old book, my lord. it is
Old
not-
book, my lord. We don't have the book, my lord. Then my lord, we'll come back again, my lord. With the,
No adjournment. No. See, once the word purchase has been substituted by the term procured,
my
the
lord.
question of
My lord, 57AE, subsection 1 and 3. If your lordship read with the rule 7(4), my lord, the rule is the Senmet credit rules to them, the manufacturer of final product must have to purchase the inputs.
sale is not required, sir.
And my lord, 57AC, subsection 3, if your lordship sees, my lord, manufacturer to prove that the inputs or capital goods were purchased and were used by him for their intended purpose. And the demand was for April 2000 to February 2002. Therefore, the rules are applicable. Normally, your lordship consider this aspect, my lord.
See, in this is prior to the amendment. What rule you have handed over? 57A(E)(3). So after that, that's what the commissioner says. The scheme was introduced to neutralize the cascading effect on duty. Criteria for availing credit are that the input should be duty paid and should be used in the manufacture of final product. Different procedural provisions have been provided in the credit rules time to time without defeating the principal object. In such a background, when the authoritative provision 57AC(3) envisage allowance of credit on inputs received used in the manufacture, the procedural provision 53AE(3) cannot be employed as a shield to disallow the credit by mechanical interpretation of the word sale or purchase. Then they refer to Blue Mountain Threads, Bharat Electric Stampings, and say that it is squarely covered by the decision of the Kolkata bench of the tribunal. Please come. This appeal filed by the revenue under section 35 capital G of the Central Excise Act 1944 is directed against the order passed by the Customs Excise Service Tax Appellate Tribunal, Kolkata, Zonal Bench, Kolkata, within bracket tribunal, in dated 23/3/2011 in appeal number capital E/467/2009. The appeal was admitted on the following substantial question of law. Page number 33 of the paper. We have heard so and so. Learned advocate, senior standing counsel of the department. The revenue was unsuccessful before the learned tribunal in their challenge to the order in original passed by the Commissioner of Central Excise dated 23/3/2009. The respondent was issued a show cause notice cum demand dated 14/5/2004. Alleging that the respondent had received soap noodles from Garden Reach factory of Messrs. Hindustan Lever Limited for manufacturing of soap on behalf of Hindustan Lever Limited, and thus the transfer did not involve sale, resulting in irregular availment of Senvat credit during the period from April 2000 to February 2002, and that they are liable for payment of central excise duty under section 11 capital A of the Act as well as liable to pay penalty under the erstwhile rule 173 capital Q of the Central Excise Rules 1944 and rule 25 of the 2002 rules. The assessee submitted their reply stating that the input soap noodle was covered under the provisions of rule 57 capital A as an input inverted comma. Full stop. That rule 57 capital A capital C within bracket 3 was a mandatory provision allowing credit of duty received in the factory of manufacture, whereas rule 57 capital A capital E within bracket 3 was a procedural provision and therefore purchase was not mandatory for availing credit. It was further contended that job workers can avail credit even when the inputs were not owned by them, and in support of the contention relied upon as many as 4 decisions of the coordinate bench of the tribunal. It was further submitted that the expression received / procured existed in the SENVAT credit rules prior to 1/4/2000 and again with effect from 1/3/2003. So it should be deemed to be existed even during the intergram period of 1/4/2000 to 28/2/2003. The adjudicating authority, namely the Commissioner of Central Excise, Calcutta Roman 5, considered the said position as well as the decisions and held that when the term purchase inverted comma was substituted by the term procured inverted comma with effect from 1/3/2003, the amended SENVAT credit rules 2000 cannot prohibit credit when input specified under rule 57 capital A read with rule 57 capital B and the conditions laid down under rule 57 capital A capital AC nowhere warranted purchase to be a sine qua non. Accordingly, taking note of the said legal position, the commissioner held that the show cause notice is commissioner dropped the proceedings. Agreed by the same, the revenue filed appeal before the tribunal. Before the learned tribunal, none appeared for the appellant revenue. Yet the learned tribunal had gone through the grounds raised and also took note of the decision of the learned coordinate bench of the tribunal in Excise Industries Limited versus Commissioner of Central Excise Haldia 2008 226 ELT 249 within bracket tribunal Kolkata bracket close, wherein the tribunal allowed credit to the job worker in respect of inputs received. Apart from that, the tribunal further the tribunal noted that the effect of the substitution of the word procured was also considered in the case of Excise Industries Limited, and the said decision was not reversed or stayed by the High Court. Thus, we find that the view that the decision taken by the tribunal is just and proper, does not call for interference. Accordingly, appeal fails dismissed. The substantial question of law framed is answered against the appellant revenue.
Grateful, my lord.
Next.
My lord, next matter, my lord, I am praying for time, my lord, because this
Matter number
matter,
6.
Mr. K.K. Maithur was there. My lord, to add till today, my lord, I have not received any brief, my lord.
Time change.
Your
Lordship, I appear also on behalf of the respondent, Your Lordship. We also seek time to be ready.
Jointly prayed.
Your Lordship, kindly direct to appellant to serve the paper book. We did not receive any paper book.
Jointly prayed adjourned. The learned advocate appearing for the appellant department shall serve copy of the paper book on the respondent on the learned advocate appearing for the respondent assessee within 2 weeks, 3 weeks. Can you
Yes.
take a photocopy? How
Oh,
they?
my lord, kindly see this volume of this.
I will take the photocopy at home
No,
at my
he is a
own
big
cost.
time assessee.
Yes, I can.
You give your copy, he will take photocopy and return.
Yes.
Just collect, give me the copy. I have the only one copy.
আমি কপি করে নিয়ে on
You
cost
ensure that you give it back to
I
him.
will ensure.
Grateful, man.
I will ensure.
Next.
Tax matters, item number 7.
So item number 7, Lordship, I am for the respondent assessee. The assessee has not yet received the papers.
No, it was returned back with a unclaimed,
May
my
a copy be served upon me, Lordship, in this matter.
There is how much delay?
80 days, 80.
All right. We have heard so and so.
But I'm late back.
There is a delay of 80 days in filing the appeal. Let copy of the stay petition be served on the learned advocate appearing for the respondent.
Yes.
Since the delay is not inordinate, the same is condoned. Application in GA 1 of 2025 is allowed.
Grateful.
Next.
Item number 8.
But I'm appearing in this case. There is delay of 129 days, my lord. Correction, what? I have filed my service, my lord.
Respondent 129 days. Delay.
There is no objection in regard to the delay, my lord.
All right. Delay condoned, sir. 129 days. Let it come for admission. Next.
Item number 9.
But item number 8, well, I'm late by Mr. Tilak Mitra, my lord. Tilak Mitra is also.
You give the slip.
Yes. My lord, I'm appearing with this delay of 250 days, my lord.
Huh?
250. Item number 9.
Due to
হ্যাঁ ঠিক আছে আমি আগে এটা মেল ওকে কারেকশনটা করে মেল করি মেল করে দিই মেল করে ওকে বলতে হবে যে স্ট্যাম্পের পরে টি ফাইনাল প্রিন্ট করে ভলিউম বানানো ভলিউম ওরা বানিয়ে ওটা কিছুই না ওটা তো ওই গ্রিন ডিডের রেজিস্ট্রি গ্রিন পেপারে
All right. You don't have papers.
I have papers, Lordship.
Today we will condone the delay. Heard so and so delay condone.
Item number 10.
For 10, my lord, I am appearing, my lord. It was served, my lord, but return back, my lord. Service.
What is the endorsement?
My lord, addressee cannot be located. The endorsement copy is not with me, my lord. Lordship again serve and then come email service, my lord. Thank you.
As the notice sent to the respondent assessee has returned, fresh notice be issued to the correct address, including and in addition, notice be served through email in the registered email ID of the assessee. When somebody, Manish Tiwari appeared.
My lord, I'll check up, my lord.
Item 11.
11, my lord, I am for the appellant, my lord. Delay of 18 days, my lord. Delay of 18 days in filing.
Respondent who will appear?
Respondents.
Where is Tapul Mehta?
For the Kolkata 7 Commissioner, my lord, service.
How many days delay?
18 days, lordship.
You have heard so and so. There is a delay of 18 days in filing the appeal. As the delay has been properly explained, the same is condoned. Application in GA 1 of 2025 is allowed. You give them papers.
Lordship.
Next.
Item number 12.
My lord, due to knee replacement, advocate and court not coming to the court. I pray before the court of list liberty to mention.
It's a residuary appeal.
It can't come.
Residuary appeal.
It's an appeal from an order passed in residuary jurisdiction.
Residuary appeal won't come here. No?
No, it will not.
It will go to appropriate bench. Let
Since this is an intra-court appeal arising out of an order passed in a writ petition filed under Group 9.
Group 9.
Since this court does not have determination to take up this matter, the same stands released and the appeal be listed before the appropriate Honorable Division Bench having determination.
For admission of tax matters, item number 13.
In this matter, Mr. Ajok Datto is appearing. He is suffering from high fever, so I'm praying for not this week.
Who will appear for the department?
Mr. Ajok Datto.
All right, adjourned.
Item number 14.
Lord, I'm appearing in this matter, Lord. We have served, Lord. They have received.
Item numbers 14, 15 and 16, Lord, I appear for the respondent. Lord, I have not received a copy of the condonation.
But there is no delay, Lord, subject to question.
There is no delay.
By mistake, there is no delay. The Black Money Act matter.
There is no delay. আজকে করি না।
করবেন তো আজকে?
না, আজকে করবো না।
বলে দিয়েছিল।
Lord, the order was passed on 7th of January 2025, my lord, and the appeal has been preferred on 3rd of July, my lord. And my lord friend is submitting that there is no delay.
Order was received subsequently by the 30th. Subject to correction.
Probably they would have received the certificate copy belatedly.
Yes.
Otherwise, office registry would not have numbered the matter.
Yes.
Then, my lord, in that case, will it be convenient for your lordships to keep it some other day? My lord friend does not oppose.
This is under the Black Money Act.
Black Money Act, yes. But the SSC has not went to Geneva, Switzerland. He has purchased. He has paid some amount, and that was that amount, regarding a business proposal was spent, and assessment.
Anjan, this is actually coming under Black Money Act, but they have numbered the matter as income tax.
Order was for the ITD.
This is in the presentation form.
Yes.
You have given it as under Income Tax Act. It's not a matter arising under Income Tax Act.
Yes.
I think we don't have determination.
Order was passed by ITD. Maybe yes. Yes, I understand. Yes.
Black Money Act also there is an officer,
yes,
but he is nominated under the Act. Where is the assessment order?
But the assessment order is not page number.
It is at page 58. Not even assessment order.
Page 11, Lordship. Page 12. Lordship.
So he is specifically nominated for that purpose.
Order he's saying that he go to some other
No, it is like an assessment order. Actually, it's not been specified. Then we'll hear the appeal, admit the appeal and hear it.
Yes, yes.
That will be better.
That will be better.
You want to file paper book?
No, all the documents are here. Let paper book dispense with me. Lordship will fix the matter.
But if you want to file a compilation, we will give you liberty. Suppose some documents
we would like to file an opposition to his stay.
There's no stay.
There is no. We are not granting.
There is a prayer for stay, my lord.
We are not granting any stay.
Very well.
We have heard the learned advocates for word. The appeal is admitted on the following substantial questions. A to E. Sir. Identical question.
Yes, yes.
A to E, page 6 and 7. It is submitted by the learned advocate appearing for the appellant department that all the relevant papers are annexed to the stay petition. Therefore, the filing of informal paper book is dispensed with, and the stay petition shall be retained. Full stop. The liberty is granted to the learned advocate appearing for the respondent to file a compilation of documents if they choose to do so, annexing the documents which were placed before the learned tribunal, and no fresh documents can be filed.
So separate orders in 3 matters.
Separate orders, sir. 14, 15,
14, 15, and 16.
16.
I'm grateful.
80, same grounds only.
Item number 17.
Grateful, Lorships.
Item 17. Who will appear for the income tax department? You will appear? There's a delay of 112 days. Serial number 17.
Serial number 17. SSC is appeal, not Your Lordship. DX may appear.
We have heard so and so. Since standing counsel had been nominated to appear for the respondent department, we have directed Mr. Procedural and a senior standing counsel to accept notice and represent the respondent department. His appearance be regularized and the fee bills submitted be honored. There is a delay of 112 days in filing the appeal. We have perused the government set out in the affidavit filed in support of the petition, and we find that sufficient cause has been shown for not preferring the appeal within the period of limitation. Accordingly, the delay is condoned. Application in GA 1 of 2025 is allowed.
Grateful.
Item number 18.
My lord, praying for a nod this week, my lord.
My lord, 18 and 19, my lord, 18 is the department's appeal, 19 is the respondent's counter appeal. My lord, it has been served just today. My lord, our appeal was taken up. Your lordship directed to file they were asking to file a counter appeal. Cross appeal, my lord, I'm sorry. Cross appeal has been filed by the respondent. They served it today. Give us a week's time so that we take.
As jointly prayed after 3 weeks.
After 3 weeks.
18 and 19.
18 and 19.
Item number 20.
After 3.
I was for the appellant for item number 17, my lord.
What did we do?
My lord, your lordship.
The delay was condoned.
Delay is condoned. Give your appeal.
Grateful, my lord.
Item number 20.
You give papers. You give papers to Mr. Dori.
Serving here and now.
Yeah, here and now. Item 20. 20. He wanted. Next week. Item 21.
Item 21.
No, I am appealing for this. I am appealing for the Union of India, man.
Respondent will appear for the income tax department.
Income tax, man.
Who will appear for the department?
Mr. Arya Dutt is appearing for the department.
Oh, he is not well.
Not well.
Next week.
Next? On any date, my lord, next week.
Yeah, date he will give.
Only Monday I will not be out of Calcutta.
Great.
My lord, one request. My lord, since new chairs have been installed, my lord, below that, if the rubber.
In fact, I have directed them to do it.
And
They missed out. Tomorrow it will be.
Otherwise, it will be confused.
But it's comfortable.
Yes, man. Only the noise is uncomfortable.
Yes. I specifically told them, I don't know how they missed it out.
Yes.
They'll come
Yes,
and
ma'am.
announce.